There you go.
Let me give you a number that keeps most people up at night. The average cost of nursing home care in South Carolina is over $8,000 a month. That's nearly $100,000 a year. And Medicare does not pay for long-term custodial care. Most people don't know about that until it's too late. I'm James Anderson with Anderson Law Firm, and today I want to talk about Medicaid planning, not Medicare, Medicaid planning, the 5-year look back, and how the right incapacity planning can make all the difference. But first, a few basics. When someone needs long-term nursing home care and they can't afford to pay $8,000 to $10,000 or more a month, Medicaid is the program that steps in. But Medicaid is a needs-based program. It's a form of welfare. To qualify, you have to have very limited assets, in most cases, no more than $2,000 for an individual. Now, here's where it gets tricky. Medicaid does not just look at what you own today. They look back 5 years from the day you apply. That's the 5-year look back period you might hear your friends talking about. If you gave away any assets, transferred property, or moved money around during those 5 years, Medicaid can impose a penalty period, meaning that they won't pay for your care even though you've spent down your assets. The penalty period is calculated based on how much you transferred, and I've seen cases where families are stuck with months or even years of uncovered nursing home costs because of transfers they didn't think would matter. So here's where incapacity planning ties in, and this is the part I really want you to hear. Remember in my incapacity video I talked about the durable power of attorney? Your durable power of attorney names an agent who can handle your finances if you cannot. But here's what most attorneys don't do. They don't include gift-giving powers in the power of attorney. Why does that matter? Because if Dad gets diagnosed with early-stage dementia at age 72, and we know he might need nursing home care in a few years, we want the ability to start making strategic, legitimate gifts now, while we still can, to get assets out of that 5-year look-back window. If Dad's power of attorney allows for gift-giving powers, his agent, maybe his wife, maybe his daughter, can begin making those transfers on his behalf, even as his cognitive ability declines. That's planning ahead. That's protecting the family home and the family savings. But if the durable power of attorney doesn't include those powers, or worse, if there is no power of attorney at all, once Dad loses capacity, you're stuck. You can't give away someone else's assets without legal authority. And by the time you get a court-appointed conservator, you may have already lost years of planning time. So let me bring this full circle. Medicaid planning isn't something you do the week before someone goes into the nursing home. It's something you build into your estate plan years in advance. And the durable power of attorney with gift-giving powers is one of the most powerful tools in that toolbox. This is why we don't do just wills. This is why every plan we build at Anderson Law Firm includes robust incapacity documents. Your trust protects your family from probate, but the durable power of attorney with the right powers can protect your family from financial devastation. If you've got aging parents, or if you're starting to think about this for yourself, don't wait. The 5-year clock is always ticking. The best time to plan was 5 years ago. The best time to plan was 5 years ago. The second best time is today. Thanks for watching. Share this one with your family. I'll see you next time.